Hello everyone, welcome to the Lex.Journey. Today we are continuing our discussion on acceptance as an element of a valid contract. Right, so earlier we discussed about acceptance and we defined acceptance as a final unqualified expression of assent to the terms of an offer. We said acceptance may be by words, conduct, and the authority for it being by conduct is Brogden. And we did the fact that acceptance must be communicated to the offeror before it becomes effective. And authority is Entos Limited versus Miles Far East, where Lord Denning gave an analogy that when you are giving an offer, when you shout an offer to someone and a plane is moving because of the sound, the person doesn't hear. You have to keep quiet. When the plane leaves, then you communicate it to the other party so that he can hear. Yeah, so all that I was trying to say is that acceptance is valid only when it is actually communicated. Yes. Note also that acceptance must be communicated through the right authority. If a person has no right to communicate the acceptance, any communication of such will be void. So authority for this is Powell versus Lee. Powell versus Lee, where the decision of the board to accept a particular person as the head teacher was communicated by a person who was not authorized to do so. So when the board changed their mind, the court held that they had not formally communicated their acceptance to Powell, so Powell had no right to sue for breach of contract. So today we'll be entering a bit more into the acceptance by post, which we said the classical authority is Adam and Lenzel. The classical authority is Adam and Lenzel, and then the rule was also extended to telegram, acceptance by telegram, and that's the case of Corner and O'Connor. The acceptance, the postal rules are extended to acceptance by telegram. So the postal rule does not apply to revocations and counter offers. Note, the postal rule only applies to communication of acceptance. So please take note if within the facts of a case, a person was communicating revocation of an offer through the post, or the person was making a counter offer through the post. The postal rule, which states that the acceptance is valid when the letter properly addressed is posted, it doesn't apply here. Therefore, the revocation or the counter offer is only valid when it is actually received or communicated to the party to whom it is addressed. Now, one thing you have to note is that the postal rule does not apply if it is unreasonable to use the post as a means of acceptance. So it must be very reasonable for you to do so. Yeah. So if within ordinary living, people normally use the post to do transaction, it may be reasonable for an offeror to expect that the offeree will accept his offer by post. If not, the postal rule will not apply. So please consider the case of Henton and Fraser. Henton and Fraser. Henton and Fraser. And also, the postal rule applies where the letter is posted. A letter is posted when it is with the post office. When it is with the post office. In the case is Royal London and Northern Bank, S. Parte Jones. Right, so this will now be the end of acceptance. Now the question is, how is an offer terminated? Now we're coming to do how an offer is terminated. So an offer may be terminated by revocation, rejection or counter offer, lapse of time, failure to comply with the condition precedent, and death of the parties. Sometimes to acceptance brings an offer to an end. So keep that in mind. So first, revocation. If I offer to sell you my phone and then later I change my mind, I must communicate it to you that I'm no longer prepared or willing to sell. And if I communicate it to you before you accept my offer to sell, I am relieved or my offer to you has been terminated. So if I say I'm selling my phone to you and I come back and tell you I don't want to sell it anymore, and this is done before you accepted it, the offer is terminated and you can no longer accept it. The authority for this is Routledge and Grant. Routledge and Grant. So yes, note that revocation can occur at any time before acceptance. Before you've accepted my offer, I can revoke it at any time, right? Okay. So in Ghana, the general rule that an offer may be revoked at any time before acceptance is applicable. It's applicable. But where the offeror promises to keep the offer open for a specified period of time before acceptance, he may not be able to revoke it anymore. You won't be able to revoke it because at the common law, even if a person promises that I'm selling this phone to you, but you have up to Friday to tell me what you think, that person was still free to revoke his offer before Friday. That's ruthless and grant. But in Ghana, this position has changed. It has been modified by Section 8, Section 1 of the Contract Act 1960, Act 25, which states that a promise to keep an offer open for a specified period of time before acceptance is binding on the offeror. Is binding on the offeror, even where no consideration is provided. Right? So please take note. And revocation of an offer is effective if it is actually communicated to the offeree, right? So even no matter the means that you are using to revoke your offer, it must be actually communicated to the offeree before it will be binding. So in other words, the offeree must have notice of the offeror's intention to revoke the offer. And the authority for this principle is Bayern versus Leon van Tienhoven. Bayern versus Leon van Tienhoven. So please take note that revocation of an offer is effective only when it is actually communicated, right? So the communication of revocation of an offer can be done by the offeror or through his agent. So the law does not impose a strict requirement that since I made the offer, I must be the same person to communicate my revocation of the offer. It may as well be done by my agent or a person who both parties reasonably can trust that has the right to revoke it. It is put this way. An offer may be revoked by the offeror himself or through a reliable third party. So a reliable third party depends on the fact of each case. So if the three of us are mutual friends, and then one of our friends come and tell you that the offer I'm offering you, I've revoked it, you may be able to believe that is true. But let's say I give you an offer and a person who's drunk comes and says, Lord, I should revoke this offer. Please, we can't term such a person who is drunk as a reliable third party. So please, it depends on the fact of each case. And the authority for this is Dickinson and Dot. Dickinson and Dot, where an offer was revoked by the agent of the offeror, and it was effective. It was held to be effective. Now, let's look at reward offers. Reward offers. Reward offers. Before we go to the next ground for revoking or for terminating an offer. The next ground. So, reward offer is where, let's say, through an advertisement, it says that anyone who finds this particular dog or this particular bicycle should come for this reward. All right. So the law is that in order to revoke your offer, which you've made, well, they call it a general offer in such context, a general offer. So in order for you to revoke this offer you've made to the public, you can only revoke it through the means that you made the offer. So, example, I went and stand at, say, TV3, and then I told the people of Ghana that I'm looking for a particular bicycle, a golden bicycle, that anyone who finds it should come for a reward. If I have found it, or by some reasons I no longer want it, and I want to revoke my offer, all I have to do is to go to that particular TV station that I went to, TV3, and say that, no, I don't want to go on with the offer anymore. And it might be effective. The authority for this is Shuey versus USA. Shuey versus USA. But you see, what about when I gave the offer, somebody has started performing or has started looking for my bicycle? Can I revoke it in such circumstances? Yes, so that's what we are coming to treat now. So the law is that in situations where a person starts performance of a unilateral offer, the offeror is not bound at the moment. So even if you start performing, at the moment he may not be bound. However, once performance of the stipulated act begins, once the performance begins, the offeror loses the power to revoke the offer. So that's what it means. I give the offer for anyone who finds my bag should come for money, right? When you start looking for it, I'm not bound by any contract yet. It's only when you bring it to me that we're bound by a contract, right? Because you haven't brought it to me, so I'm not bound. However, the law imposes a restriction on me not to revoke it if people have started performing. So although I'm not immediately bound as soon as you start looking for my bicycle, I also cannot revoke it whilst you have started the performance. Yes, I also can't revoke it. So an illustration is the case of Dahlia versus Formel Bank nominees by Goff LJ. Please read Goff LJ's formulation in that case. And also in Arrington versus Arrington and Wood, or Arrington and Arrington, where Lord Denham did a very good analysis in that case. So in that case, an offer was given by, all right, thank you. So an offer was given by a parent, or he gave a house to his daughter-in-law and his son, that if they're able to pay off the balance of the house, they should keep it. The man died, and later his the executors of the man, came to say they are revoking the offer, so they are taking back the house. But in this case, Lord then held that so far as the couple have started paying, there was no way that offer could be revoked. So note, if I make an offer to people or to a person, he start performing it, immediately I'm not bound. However, I cannot revoke it if the performance has started. And the authorities, Dahlia versus Formel Bank nominees, and Arrington and Arrington. Right. So we are now done with revocation in respect of all that we needed to do. Now we are going to the next ground on which an offer may be terminated. That is rejection. Right. Rejection or counter offer. So if I give you an offer that I want to sell a particular thing, and then you tell me, no, I don't want it, the offer is dead. The offer is terminated. You can't later come and accept it again. So this is what we call outright rejection of my offer. And there's another instance. This is the more technical aspect. We call something counter offer. So say I tell you that I want to sell my phone to you for 1,000 Ghana cedis. And you tell me, no, I want to buy it at 950 Ghana cedis. What you did in law is also rejection of my offer. And it is called a counter offer. Because when I give the offer of selling my phone, or you buy my phone at 1,000, you have given me your own offer to buy it at what? 950. So what you did is a counter offer. You are countering my offer. And the legal effect of a counter offer is that it terminates, or it rejects and terminates my initial offer. And you can no longer accept it subsequently. So you can't change your mind and say, oh Lord, now I want to accept it at 1,000. If I want, I'll sell it to you. If I don't want, I won't sell it to you. Or if I want, I won't sell it to you. And I will incur no legal liability, or I won't be liable for any breach of contract. Right? So that's by rejection. So the authority for this is hide and wrench. Hide and wrench. And the Ghanaian case of Degwe versus Insia and Antonelli. Now, lapse of time, if I give an offer and I give you a time that I want to hear from you by Monday I won't sell again. If you accept it on Tuesday, my offer was already terminated on Monday, so you can't accept it on Tuesday. So lapse of time can terminate an offer. And the case is Ramsgate Victoria Hotel versus Montefiore. Right. So also know the case of Canadian and Co., where the court said that the mode that the offer is made may note that acceptance must be made within a short period of time. So sometimes the more that I make the offer, it can suggest that you have to accept it quickly. Even though I haven't told you the particular time, you have to accept it quickly. In the case is Canadian and Co.